Hello and a very warm welcome to you. This is the Courthouse, our Law Class 101, where we get to learn the law in plain, simple and entertaining language. We've been looking at activities of the judiciary in Nigeria. We've also taken a look at some very interesting legislations. And of course, we are talking about issues that affect you and I in this law class. And of course, you know we have interesting jargons for you all the time. I am S.A.N. Olomu-Agbodo. We'll go on a quick break. We'll be right back. You're welcome back. If you just joined us, this is the Courthouse, and this week on the show we are taking a look at the issue of community policing, state police. What is the legal procedure for creating a state police? And as usual, we're joined by a seasoned legal practitioner. Not just any legal practitioner, he's a senior advocate of Nigeria, and he is Godwin Omoaka. Thank you for being here again, sir.
Thank you for having me.
Okay, so now of recent, we've been hearing about community policing, we've been hearing about state police. First of all, can you help us distinguish between those two concepts? Are they one and the same thing?
So they're not necessarily the same. Now, when you talk about state police, you're talking about the police that belongs to the federating unit of the Federal Republic of Nigeria. For instance, the Nigerian Police Force as we have it, or the police for the various states.
Okay.
All right. So when you use that language, state, you're referring to these institutions that are created by law for the state, either at the federal level or at the state level. When you talk about community policing, it's a different concept entirely. So either the state police can be involved in community policing, and individuals as well, all right, who are not necessarily police officers and organizations can also be involved in community policing, such as you have the
various vigilante groups.
Yeah, the various vigilante groups, the Joint Task Force in the northern part of Nigeria, Zamfara, Sokoto State, Hisba in Kano State, although the Hisba has a law also backing it. So all these are actually community
police apparatus.
Yeah, police apparatus, because they are more in sync with the various communities that they are located in, as opposed to the state police, which have a very broader spread, which are the broader state. So community policing actually refers to focusing more on a particular locality, using individuals, vigilantes, and all over to prevent the commission of crime and to enforce law and order in that community. And that society. Okay,
so now, because recently we also heard about another security outfit created by the Southwestern governors, and it's generated a lot of controversy, the Operation Amotekun. So that one, is that supposed to be like another vigilante group, like another community policing group, or is it a state police outfit?
So for me, it is more of the latter. It is more of the former, a community policing outfit.
Okay.
Don't forget that we have several of these community policing outfits across the country. You have vigilante groups. So what is, it's called the Western Nigeria Security Outfit, aka Amotekun. I don't think that they are a police in the strict sense of the word. Don't forget that under the Constitution, specifically Section 214, the country Nigeria can only have one police force. So no state or no constituent part of Nigeria has the powers to create another police force. But we can create vigilantes. We can create individual and corporate security outfits that can protect lives and properties of our citizens. For instance, we have so many people who employ security men in their houses to protect them. If you go to various streets, some have street security, Some even have community security. So what the governors of the 6 Western states have done is not really unusual. I think given the present security challenges that we are facing in this country, the issues of the headmen, kidnapping and all of that, I think it's very timely. And I think there's nothing unconstitutional about it. There's nothing wrong about it. Don't forget, under Section 14, subsection 2B of the Constitution, the responsibility of government is primarily to protect lives and property
of the citizens.
And then I think Section 176 of the Constitution also provides that the governors of the states are the chief law officers. Yes, the chief security officers for the states. So they've come together. They've put together this outfit, which is essentially complementary to the Nigerian police force. What are they going to do? Intelligence gathering, arresting of offenders, and providing assistance and intelligence to the Nigerian police force, which we even do. Individuals are encouraged by our various criminal procedural laws to do.
Yes.
In fact, you have the power. Everybody has the power to apprehend a criminal on the road, suspects on the road, and hand them over to the police for prosecution. So I don't think there is anything unconstitutional about that.
So why then did the Attorney General of the Federation declare them illegal?
To be honest with you, I think it's more political than legal.
Okay.
I don't think there's any legal justification. Yes, an argument can be made for the enactment of laws by the various states to back it up, just as we have seen has been done with the Hisba in Kano State, all right? But that does not mean that it is illegal. In Kano State, right, you have the Hisba. Why didn't the Attorney General say it's illegal? Because it has a law. What about the Joint Task Force, the civilian Joint Task Force in Zamfara, Sokoto State that are involved in the fight against Boko Haram, made up of about 20,000 civilians? So why didn't you declare those ones to be illegal? In any way, having said that, the Attorney General does not even have the power to declare the Western Nigeria, security outfit illegal. If he's aggrieved, then he should go to the court. It is only the court, by virtue of Section 6 of the Constitution, that has the power, the constitutional power, to declare the security outfit as illegal. For me, it is no more than a community policing effort. Okay,
which is actually necessary and which is actually a civic obligation, if I may add. Yeah. Then what about now looking at the fact that based on Section 214, we have one police force in Nigeria, and we've been hearing about state policing, creating state policing. Tell us a bit about the procedure, if there are any, to actually create such.
I think we must necessarily begin by looking at Section 214. Section 214 not only states that there should be one police force in the Nigerian police force. It says there should be one police force in the country. I think I have the section here, if I can even read it. It says, there shall be a police force for Nigeria, which shall be known as the Nigerian police force. And subject to the provisions of this section, no other police force shall be established for the Federation or any part thereof. Say no other police force. So we must begin by amending
that section.
That would be the start-off point. Section 14 has to be amended by the National Assembly and the other states of our assemblies to ensure that power, is given to the various states assemblies to be able to create
their own
police force. Otherwise, you will have what we have right now, where they simply come out with a security outfit, which is not a police, but something akin to Hisba, akin to Amotekun that you are saying right now. So that is the starting point. The Constitution has to be amended. If the Constitution is not amended, then I don't think we'll be able to create
the state
police.
Okay, so I mentioned Section 214 of the 1999 Constitution as amended, which you said should actually be amended for the various states to be able to have their own police outfits. But in Lagos State, southwest Nigeria, we have the neighborhood police watch or something like that. So is there any law backing that? And if there's any law backing that, does that constitute a state police outfit or another vigilante group?
I think there's the law by the Lagos State Assembly backing that. It is not a state police. It should not be mistaken as a state police. It is more an outfit that is responsible for, again, I mean, taking care of community policing, gathering information, providing intelligence, apprehending criminals or persons who are suspected to have committed crimes, and then handing them over to the appropriate authority, in this case, the police, for prosecution.
Okay.
They are not state police. And they have a law to back the Lagos State Neighborhood Watch that was created by the Lagos State government.
Okay, now there's a lot to back them up. Is it that, let's go back to the Western security outfits again. Is it that there's no law backing that? And if there wasn't any law backing that, is there any way to regularize the stand of that outfit to make it legal in the sight of the law or the Attorney General, for instance, now?
That's a very good question. The argument is that a law should be enacted by by the assembly of each state to back it up. As we speak, I think there's a meeting by the Attorney Generals of the six states holding today in Ibadan to deliberate on a law. But my position is that given the function and the purpose for which the Western Nigeria security outfit is created, I think there are enough laws, sufficient laws in the country, particularly the Constitution, that backs it up, all right? Then, of course, you look at Section 33A of the Constitution, which says that everybody has a right to protect his life and property. So, yes, the argument could be made that you need a law to be enacted by the House of Assembly of each of the 6 Western states to back it up. But I think that there are sufficient laws for it to operate, given that it is not a police. And what it simply seeks to do is to monitor activities within the various states, complement the police where they are not available, where they are lacking, arrest offenders, and hand them over to the police. I think we have sufficient laws in our country, fundamental laws, you know, that, and within the Constitution, to back that up.
Quite interesting. Well, we've been listening to Godwin Omoaka, Senior Advocate of Nigeria, and he's been talking about the provision of the law empowering the states or otherwise to create state police. And of course, Section 214, which he referred to of the 1999 Constitution, states that there shall be only one police force. That is the Nigerian police force at the federal level. There is no provision for the creation of state police yet. So that section should be amended. Section 214 of the 1999 Constitution should be amended for us to have various states police. And we want to take a listen to our reports on this issue. And of course, we'll see some of our legal nuggets. We'll be right back. The need to properly and effectively police Nigeria according to global best practices came to the fore recently when South-South governors, the police high command and other stakeholders held a one-day security summit in Asaba, the Delta State capital. In a communique that was released at the end of the summit, Inspector General of Police Abubakar Adamu, who was in attendance, and representatives of all governments in the region endorsed community policing as a solution to stopping increased crime and general insecurity. Two intertwining issues arrive on policing the nation. The first is the idea of community policing. The other has to do with the command structure of the present police force. Community policing is generally seen as the way to go, as it involves grassroots participation. It also has to be noted that if Section 214 of the 1999 Constitution is not amended, states cannot create their own police force. Welcome back. If you just joined us, this is the Courthouse, and this week on the show we are talking about state policing. Does the law empower Nigerians to have various state police or the 36 states of Nigeria? No. So we are calling for the amendment of the provision of Section 214 of the 1999 Constitution as amended. And as usual, I still have my guest, a very erudite scholar and a senior advocate of Nigeria with me in the Courthouse today, Godwin Omoaka. Thank you for still being here. So now looking at the need to amend Section 214 of the Constitution, and of course some other sections that people like you and other legal minds have been calling for amendment to. Can you just give us a peek into the procedure for amending any section of the Constitution?
Well, it has to begin with the National Assembly. Both houses of the National Assembly has to move a motion for the amendment of that section.
Okay.
By, I think, two-thirds majority of each house. We have to pass it, you know, and then of course I think they must get concurrence from the State House of Assembly as well, and eventually a bill will be passed to the President for assent. So I think the procedure is very clear and it's very straightforward to amending that provision, that particular.
Okay. But a lot of people have been saying, even lawyers, even the Senate, they keep saying that it's quite cumbersome to amend any section of the Constitution. So your position is different?
No, it's not different because, to be honest, to get two-thirds majority is not easy in a country that is as politically divided as Nigeria on issues. Don't forget that community policing is an issue that is very controversial. Sorry, state police.
State police
is an issue that is very controversial because of the political undertones and the fact that we are not able to manage anything in this country. So yes, the provisions of the Constitution, it's difficult, it's cumbersome to amend, but I think with determination, with goodwill, and with this sense of purpose for this country, we should be able to achieve that. After all, we've had the third alteration, the third amendment.
Yes.
How did they do that? It's cumbersome, but it was done.
But it was done.
Do you understand?
Okay.
So I believe it can be done.
Okay.
Especially if we really want to take forward this idea of allowing the states to have their own police force, because given the present-day realities, I think it's about time that the states have their police force.
Okay, so I'm going to ask you one political question now. Lagos State, Southwest Nigeria seem to be doing well financially, seem to be on autopilot basically, and that's why we have the neighborhood security watch that's being catered for by the states, by the government. And some of these other states, these other 36 states, they are having issues paying salaries, having issues even taking care of their roads and basic amenities. So how do you think they can cope with, of course, if they have state police, they have to cater for this police force, they have to cater for the equipment, funding, everything they need. So do you think they can actually achieve that?
I think with will, transparency and accountability, it can be achieved. Let me be honest with you. Even as of today, the various state governments have been providing significant financial assistance to the Nigerian police force. They buy vehicles,
yes,
they buy equipment. So I don't think there is anything necessarily different. You made a vital point that some of the states in the country may not be financially viable as states. I mean, that argument has always been there, and we can't run away from it. But I think one of the biggest issue we have to address is corruption.
Corruption.
I think there's enough money in this country and by the various states to fund the police, the state police, if they sincerely want to. The security votes that the state governments get, what do they do with them? What do they do with them? You hear cases of misappropriation of public funds. If all of these are channeled towards where they should be appropriately used, then we should not be having this argument, all right? Some of them say they cannot pay minimum wage, but some states are right now paying minimum wage. So the question of what I call accountability, transparency, and that will to do it, I think the money is there. they can do it.
Quite interesting. Like I said, I knew I was going to delve into politics by asking you that question. But we have another segment, is the bar book. And we call for Latin maxims. You know that segment. And you know you've been talking very, very seriously. We just want you to relax, give us a Latin maxim and probably smile. So let me go first, because you have a lot, so let me just take my simple one. Let me use the nolli prosecute. Nolli prosecute is a term saying that you should not prosecute, and it usually originates from the office of the Attorney General. So that's my Latin maxim.
Mine will be quick plantator.
Solo sit it.
In other words, he who owns the land owns whatever is on the land. So if you go and take somebody's land and build a house on it, know that that house does not belong to you. It belongs to the owner of the house.
So you probably have gifted the owner.
Thank you.
The mansion.
The mansion.
Okay, quite interesting, but you get to find out more Latin maxims and their meanings in our bar book segment. Stay with us. You're welcome back. Well, we've been receiving some questions from you, and of course we have a legal analyst always ready to provide answers for you. We have Femi Aborishade, a renowned author and legal practitioner, who will be answering this question on termination of contract of employment. Take a listen.
There is no universal procedure for determination of employment. What the law provides is that there should be substantive fairness and procedural fairness. This is by ILO Convention on Termination of Employment, Convention number 158 and recommendation number 166. However, the convention number 158 and recommendation 166 are often observed as far as employment with statutory flavor is concerned. We have two main types of employment. Employment with statutory flavor, having to do with employment in the public sector, referring to those who are employed in government agencies or public government-owned enterprises. The most important thing is that once your employment is with statutory flavor, the law will insist that there should be substantive fairness and procedural fairness. However, as far as master-servant relationship or master-servant employment is concerned, whether there is substantive fairness or procedural fairness, once the employer determines the employment of a worker, that employment, whether wrongful or not, will still be regarded to have been determined.
Well, quite interesting. We would like to keep getting your questions, so keep those questions coming in. You can use our hashtag the courthouse, hashtag Love Applause to join in all our conversations. We want to hear from you, and we want your questions to come in. Even if you have national issues, training issues, keep your questions coming in, keep your comments coming in. But before we go, I must say a very big thank you to you for making our time to be here this week on the courthouse.
Thank you for having me.
Thank you, sir. Well, you can also download our app, Love Applause, on any of the mobile app stores, and we'd like you to also visit our website to drop those your comments or to get updates on www.loveapplause.tv, and you can send emails to info@loveapplause.org, and numbers, your comments should come to the numbers shown on your screen now. I am Olomu-Agbodo. I say don't just get mad, go get a lawyer. Bye for now.